Okay, so it's 3:07 now p.m. here on the east coast of the United States. Good morning, good afternoon, good evening, wherever you are. Welcome everyone. My name is Xiao Recio Blanco. I am the director of the Ocean Program at the Environmental Law Institute, or ELI, and it is my pleasure to welcome you and to be your moderator today for this webinar on the importance of the regulatory reforms for the management of small-scale fisheries. This webinar also marks a milestone for ELI because we are presenting the Small-Scale Fisheries Law and Governance Toolkit, a document in which we have summarized a methodology for regulatory reforms, especially targeted to promoting co-management mechanisms in the small-scale fishing sector, along with model legal language for its implementation. Thank you so much to everyone for joining us today. A nuestros amigos hispanohablantes, si desean escuchar la traducción simultánea en español, por favor seleccionen el idioma español en la opción idioma, que debería estar en la parte inferior de sus pantallas. Y también pueden enviar sus preguntas si lo desean directamente en español, escribiéndolas en la ventana de preguntas y respuestas de la plataforma Zoom. Today, we would like to offer different perspectives about why having a specific regulatory approach for small-scale fisheries governance is important. And for that, we are grateful to the extraordinary group of panelists that have agreed to join us today. Before we hear from them, however, I will start by giving a brief introduction about ELI and the Ocean Program, and I will provide an overview of the Small-Scale Fisheries Toolkit. I also want to start by thanking the Oak Foundation for their continuous support to ELI's work on the small-scale fisheries and for providing the means to bring the Small-Scale Fisheries Toolkit into existence. And I also want to thank our colleagues from Parliamentarians for Global Action, or PGA, for joining us in this journey, and we will be hearing from them later. And as always, also a special thanks to the Naomi and the Maya Cohen Foundation, which supports the ELI Ocean Program webinar since the very beginning. We have a great panel for you today, and I will introduce each of the panelists before they speak. Before we get to the content, I want to point out a few housekeeping notes. After my introduction on the Small-Scale Fisheries Toolkit is done, we will hear the presentations from the panelists, and we will have time for questions at the end. If you have questions, you can type them in the box in your screen, at the bottom of your screen. We will compile all the questions, and we always try to get as many answered as we can. Now, moving on, a few notes on the Environmental Law Institute. We are a non-partisan independent research and education center funded in 1969. And if you have attended other ELI Ocean webinars, you have probably seen this before. ELI was funded the same year the Beatles released Abbey Road, which is also the same year that the National Environmental Policy Act, or NEPA, was passed. And for more than 50 years, ELI has contributed to develop environmental governance in more than 90 different countries. At ELI, we seek to provide avenues for the most effective ocean stewardship. We are a small, independent research center, and we do not engage in campaigns or lobbying. But we often work with organizations that use the outcomes of our research for their own advocacy campaigns. And of course, we do strongly believe that the marine environment and the communities that depend on it are vulnerable. And this need for adequate stewardship of the ocean resources is what led us to focus on the governance of the small-scale fisheries sector, and to our partnership with Parliamentarians for Global Action for preparing the Small-Scale Fisheries Toolkit, or the SSF tool. The importance of small-scale fisheries should not be overlooked. About 90% of the world's 120 million captured fishers are involved in small-scale fishing. Small-scale fisheries are extremely diverse, ranging from traditional indigenous fishing practices to semi-industrialized fishing in some areas. seeking to provide guidance on how to promote a more sustainable small-scale fishing sector, the FAO, the Food and Agriculture Organization of the United Nations, published the Voluntary Guidelines for Sustainable Small-Scale Fisheries. Among many other aspects, the document stresses the close connection between sustainable fisheries governance, environmental stewardship, and the central role of fisheries for protecting the human rights and economic security of tens of thousands of small-scale fishing communities around the world. The connection between environmental sustainability and human security rights in small-scale fisheries is what led to ELI's partnership with Parliamentarians for Global Action, and we will be hearing from their Oceans Campaign Director, Leila Nikju, in a few minutes. In addition, PGA member, the Honorable Marcela Aguinaga of the Parliament of Ecuador, has kindly submitted a recorded presentation for us. She was supposed to speak today, but has had a last minute urgent matter that needs to attend to, but took the time to record a presentation for us, and we are very grateful for that. And to understand the importance of having regulatory frameworks oriented to small-scale fisheries governance in different contexts, we will be hearing from RARE's Vice President for the Philippines, Rocky Sanchez Tirona, and from legal scholar Rocío Parra Cortés from the Pontificia Universidad Católica de Chile. Now, to explain the rationale for the Small-Scale Fisheries Toolkit, I'm going to take you back a few years. For several years, ELI was engaged in an extensive review of environmental law around the world, which led to the publication of the first Environmental Rule of Law report in 2019, and in partnership with UN Environment. The report found that the number of countries with framework environmental laws has raised from just 3 in the early 70s to nearly every country in the world in 2017. These efforts have slowed down environmental degradation, but most laws that promote sustainability struggle in their implementation and enforcement. Laws often lack clear mandates, insert concepts that are not developed, or introduce policy approaches that are not tailored to the needs and conditions on the ground. Besides, agencies implementing sustainable use of natural resources are often underfunded and find themselves as very politically weak, especially in comparison to the ministries that are responsible for economic development or natural resource exploitation in a traditional way, sort of speaking. When we zoom in on the management of fisheries, we see many similarities. Sustainable fisheries law, or the concept of sustainable fisheries, is about turning science into real change. Science helped develop concepts like fishery sustainability, which were then inserted in legal text, but without further development on how to translate those concepts into governance institutions and regulatory procedures. As a consequence, although a Fisheries Act may mention, for example, the right to community participation in governance, the regulated community does not know how to exercise that right. The government agent many times does not know how to enable that process. And this is where we think that legal analysis can prove more useful, turning research into real actionable rules and identifiable processes. Most of this action needs to happen at the regulation level, not so much at the General Framework Act level. And this is exactly the knowledge gap that we have addressed with the Small-Scale Fisheries Toolkit. The toolkit identifies useful regulatory approaches for small-scale fisheries governance with a special focus on co-management, and provides this information in the form of model legal language so that others may be able to review the language and adapt it to the legal framework of a specific country or region. Now, this is not an easy task because the reality of small-scale fisheries is extremely diverse. Just to provide an example, we were not able to identify 2 identical or similar legal definitions of small-scale fisheries during our research. But this diversity is not incompatible with recognizing that there are a number of common problems and potential solutions for the small-scale fishing sector. What needs to be dynamic and what needs to have a much more level of detail is the variety of regulatory approaches for implementing those solutions. And that is the information we have attempted to include in this toolkit. The toolkit starts by presenting a methodology for assessing the need of regulatory reforms with a specific lens on the challenges and needs of the small-scale fishing sector. And then given the central role that co-management has on sustainable small-scale fisheries governance, the toolkit focuses on creating and implementing co-management systems along two basic governance elements that help strengthen co-management: exclusive fishing rights for the small-scale fishing communities and the creation of exclusive fishing zones for the small-scale fishing sector. The three remaining parts of the toolkit address other fundamental elements for enhancing the likelihood of success of sustainable small-scale fisheries governance: strengthening compliance, overcoming the traditional discourse of opposition or conflict between fishing, coastal fishing and marine protected areas, and inserting the small-scale fisheries governance within other broader area-based ocean management approaches like marine spatial planning. To provide just a couple quick examples, you can see here a section of one of those you can see now on the screen. The goal for us was to make the model legal language included in the toolkit specific enough to really help advance and provide good ideas on how to implement sustainable governance and by providing detailed models, but at the same time, general enough so that the language can be applied to different contexts and legal systems. And the approach is to go back to the original idea that I was mentioning at the beginning. Many countries have already enacted sustainable fisheries acts, but need to flesh out how those sustainable management systems work, usually at the regulation or the local ordinance level. So for example, in the case of creating co-management mechanism, the toolkit will be successful in our hope if it's able to help a policymaker answer the question, can my country legal framework provide better guidance to achieve these objectives? The small-scale fisheries toolkit is currently available for download on the ELI website, eli.org. And in addition, we are preparing a summary for policymakers that will be also available soon. And we have also created a video of about 3 minutes that helps explain the project in very simple terms. To conclude, I just want to highlight that developing a model legal language is only one small step in a big process. For any policy on small-scale fisheries governance to be really successful, the legal drafter in each country needs to be knowledgeable about the challenge, about what is the reality of the small-scale fishing sector in his or her country. And this is usually not the case because, as we have mentioned, small-scale fishing is not a main priority for most policymakers. And that is one of the main reasons why the cooperation with Parliamentarians for Global Action was so important and so rewarding for us. And with that, my introduction to the topic is over, and I will go ahead and introduce our first panelist, Leila Nikju. Leila is a lawyer and an environmental consultant with over 10 years of experience in leading international law and public policy campaigns. In 2016, she worked with PGA on developing the Parliamentary Oceans Campaign to support the implementation of SDG 14, the Sustainable Development Goal that addresses ocean issues. And she currently works with PGA on expanding this portfolio of ocean initiatives. And besides all that, she's a passionate diver and surfer. So thank you so much, Leila, and I think I can stop sharing my screen now so that you can go ahead with your presentation.
Thank you so much, Xiao. Great to be here today. It's a new experience to speak to an audience that we cannot see. So I'm going to keep my presentation short. I cannot see if anyone is bored, so I want to be sensitive towards that. And there is a lot of time in the end for questions and answers. So I will give a broad overview, and then if you have more detailed questions about any part, just let me know. At Parliamentarians for Global Action, we are really grateful to ELI for the partnership. We have also collaborated in the past, more in conversations and planning together with RARE, so it's really great to be here on this panel together. I will give a little bit an overview over PGA for those who don't know PGA, but really I think you will learn much more about PGA after me when we have the video from our member Marcella, who will give you the experience on the ground. And I think that's what PGA is really about the direct connection with parliamentarians, about bringing those issues to the national parliaments and working with them on how to address it, how to challenge legislation that is existing and work on implementation. So PGA was founded in 1978, and the background was the time of the Cold War, and the focus was more on nuclear disarmament back then. But since then, PGA has led many, many campaigns on disarmament, the International Criminal Court, women's issues, but never really about environmental issues until we started developing the Oceans Campaign. And the reason for that was that a lot of members of parliament who are on the board of PGA saw that there are parliamentary networks who are working on the environment, but there's nobody really addressing ocean issues yet. And they thought that's a big gap. And so in 2016, at the board meeting of PGA in Senegal, there was a decision by the PGA board and the International Council, members of parliament from all around the world, to start working in particular on the implementation of SDG 14. With all that, we got lucky to meet Xiao and to start working together on sustainable small-scale fisheries. And the background on this is that really PGA thought that a healthy environment and a healthy ocean is really very closely related to human rights, because PGA members believe that there is a right to live in a healthy environment and that environmental issues and human rights issues cannot be separated. A lot of times, specifically with fisheries issues, we are talking about the rights of people working on the fishing boats, the right to food, issues of poverty, and it's usually those nations that are already struggling the most with food security that are affected by issues in the fisheries sector. Because as Xiao has mentioned in the past, small-scale fisheries is not really a small-scale issue. It affects millions of people around the world, and those people are represented by elected parliamentarians. So the members of parliament thought it is their obligation to engage here, and many of them represent coastal communities and want to basically give a voice to the people living in those coastal communities. So they see that there is like a responsibility to protect the people living in their constituencies. And in this sense, PGA both works bottoms up and top down. So we work together with members of parliament who are representing the local communities. We work together with grassroots organizations on the ground. But then we also work through the members of parliament with governments. In many countries, members of parliaments can be members of parliaments, but at the same time also ministers. So there is a number of members who are also ministers and who working on this directly with governments, basically on the government side. And at the same time, many members are from the opposition. So those members a lot of times have a chance to challenge their governments. And as Xiao said, it's an issue of co-management, of collaboration, but it's also a big issue of priorities. Because I think one of the reasons why there is not much regulation on small-scale fisheries is that it's a topic that a lot of times is not on the main agenda of governments. It's not a topic that they give their first priority focus to. And through members of parliament, by them engaging in their oversight responsibility and by them creating more transparency on what's going on in the government, they make sure that this becomes a priority. So I believe that parliamentarians in many ways are kind of the missing piece between what is going on in government and grassroots organizations, NGOs. And I think it's really important to bring in that connection. We try to facilitate to have NGOs and academics speak to members of parliaments and help them educate and raise awareness about the issues, bring them back to what's happening in their local communities. And at the same time, then the parliamentarians are in a position to have a better voice to address their governments. So PGA is working on issues of small-scale fisheries, illegal fisheries, also looking right now to work on working on issues of deep seabed mining, marine protected areas, marine litter. In many of these areas, we have a constant discourse and engagement with ELI. And the methodology PGA is using is basically the first step would be an in-country analysis. And that's where the small scale fisheries toolkit is extremely useful to members of parliament, because it gives them and their legal drafters an opportunity to have a step-by-step approach on what regulations are there in my country, what is the political landscape, and what is also the actual landscapes. What does it look like engaging with local fishermen, and assess the situation on the ground. So that would be part of the country analysis. And then as a team, we also work with doing a political analysis, looking into electoral cycles, engaging with the media, assessing who are those members of parliament who could be more interested, and then working together with national parliamentary groups, such as, for example, the one in Ecuador, on addressing the issues directly in the relevant committees in parliament. So one of the first steps, as I said, is analyzing a little bit the situation in the country together with members of parliament, educating members and raising awareness together with NGOs that we partner with. And then usually members of parliaments become champions. There is always some parliamentarians who are particularly interested in the issue. It could be based on what is going on in their constituencies, or a personal passion, or because they are in the committees dealing with those issues. So I think one of the most important and critical things is that PGA is using a peer-to-peer methodology, where those champion MPs then speak to their ministers, speak to their colleagues in parliaments, organize roundtables where we invite experts. Now, with COVID-19, a lot of it has been happening online, and it has worked surprisingly really well. This gives a new opportunity to connect people from all around the world on a low budget. But of course, meeting in person can sometimes be even more effective. And then we see through members of parliaments and NGO communities in the countries, we learn about the existing obstacles on the ground, and we work then together with the NGOs on the ground and the parliamentarians on overcoming the obstacles. Sometimes there will be a sharing of best practices where there is another country that has PGA members who already experienced similar obstacles, and then we organize more like a regional roundtable to see, can we learn something from another country, or can there be international support to overcome any challenges? And once a year, PGA has an annual meeting where members of parliament from all around the world come together. For example, last year, the issue, I'm thinking last year, but actually 2019, the issue was oceans. So we held the first International Parliamentary Oceans Day, and we had members from over 50 countries come together and discuss ocean challenges. ELI was, of course, also there. So yes, I think that's a little bit of an overview on how we work and how we've been working together with ELI and other NGOs. And we are available, of course, for any questions. Thanks a lot.
Oh, thank you. Thank you very much, Leila. And yes, as I said before, the partnership with PGA has been very productive. And I, of course, see lots of advantages from the research community to engage with parliamentarians. But as we have discussed before, we also see a great potential on connecting parliamentarians with the small scale fishing communities themselves, which are in great need of having a more like political support and having their voice heard on the big decision-making processes. Um, so thank you so much, Leila, for that. We will, as I mentioned, move on to our next panelist, Deputy Marcela Aguinaga from Ecuador. She's the former Ministry of the Environment of Ecuador, and she participated actually on the development of the new organic law for the development of aquaculture and fishing, which was published in April 2020. So very recent legal development in Ecuador. As I mentioned, she unfortunately will not be able to participate live, but she has been kind enough to submit a video, and we will be now watching that video. Thank you.
Hello, everybody. One of the great challenges that we have in Ecuador in terms of fishing is to balance respect, justice, and conservation between high scale fishing and small scale fishing or artisan fishing. Let's remember that Ecuador, according to FAO data, is one of the countries in the region where there is extractions of transzone fish and highly migratory fish, such as pelagic fish, demersal species, and also sea fish, sea shrimp fishing. In Ecuador, we have this special characteristic compared to other countries in the region. Inside our jurisdiction, we have this special place called the Galapagos Island. They are the mankind's natural heritage, and in addition, they correspond to a marine reserve protected by the Equatorian state. The Galapagos National Park they needs to face challenges. For example, illegal fishing, and in addition to this, the pressure in this exclusive economic zone. There are international ships, different flags that want to go illegally inside that marine reserve and being mother ships for the fishing that is done inside this area. Therefore, through the National Assembly in the past years, we have wanted to improve laws and improve institutionality so that we can actually give governance not only to our coastal profile but to protected areas where there is fishing as one of the main activities. In the institutional framework, we must say that Ecuador recently passed this new fishing law in our country. We have decided to giving the ruling body to the ministry in charge of aquaculture and fishing policy. The ministry needs to plan, regulate, coordinate, manage, and evaluate everything that is related to sustainable activities, aquaculture, fishing activities, and the alike. Also, sustainable use of hydrobiological resources so that it's not only about conserving long-term resources, but they want to assist effectively those sectors whose economic activity depend on fishing. There are some important principles in relation to public policy. Talking about governance, first of all, there has to be regulating frameworks, but there need to be short and long term policies through conventional ways to manage. It is important to say that in the case of marine reserves or national parks that have fishing activities, the regulating body is not the Ecuadorian Fishing Authority, but it is the Ministry of Environment. It is also important to mention that within regulations that I just mentioned, there are different activities that have been regulated. For example, artisan fishing, scientific research fishing, subsistence fishing, combating illegal fishing, industrial fishing, and we acknowledge that artisan fishing is this activity that is done individually or collectively, autonomously, by men or women in those communities that are in coastal areas, waterfronts, inland waters, or island waters. These types of activities need to focus not only to improve quality of life of citizens, but to contribute to food sovereignty in our country. In addition to this, there has been fishing regulation and there are mechanisms for governance, sustainability of hydrobiological resources so that there can be better benefits, not only economic but also social and environmental benefits with the ecosystemic approach. For this purpose, this regulation measures there is this technical report by the Public Research Institute and there is also a fishing sector is we share information and scientific evidence and knowledge of our communities so that we can ensure conditions so that those populations and the status of fisheries are not altered in terms of sustainability. It is important to mention as well that these activities have some restrictions, like in the reserve areas for reproduction, those areas that are destined to hydrobiological resource reproduction. So we have the low tide through the continental coast to a distance towards the sea of at least 1 mile. In this area, the area called the Mile in Ecuador, there are some actions that are allowed. Manual collection and captures of crustaceans and shellfish. There is use of different artisan equipment determined by the regulating body, not just any type of fishing. Third, we also have sports fishing with hand line. We also have capture of crustaceans and shellfish and other hydrobiological resources, sports, diving, and mariculture, artisan mariculture, and extraction of other resources within the modalities of fishing just with scientific purposes. I must say and acknowledge that mile protection has been really done through many years by the artisan fishing sector so that in the mile we can conserve hydrobiological resources and sustainability is kept as well. Similarly, we have this fishing area for artisan fishermen that is called the 8 Mile area. That is where we have recruiting processes of bioaquatic species, low tide through the continental coast towards the sea, excepting for that the mile, that one first mile. It is important to mention as well that This area, the 8 Mile area, has the possibility to have certain type of fisheries and using certain types of fishing arts with some restrictions. Some measures that have brought conflict between artisan fishermen and industrial fishermen. At some point in time, industrial fishermen um, had an argument, they had conflicts with artisan fishermen. But I must say that up to this date, inside that 8 Mile area, we need to have scientific fishing activities and that has the regulating fishing system so that we have capture quotas, seasons. We also have different fishing methods, minimum sizes to capture, and other regulations to preserve hydrobiological resources. We must acknowledge that there is a discussion to increase beyond the 8 miles. The idea is to expand the 8 Mile area, always as and give a priority to artisan fishermen. In this 8 Mile area, industrial fishing is prohibited. Certain ships, industrial fishing ships, do not respect the possibility of not going into the 8 Mile area that is reserved for artisan fishing. There is conflict within the different operations in Ecuador. There are some activities that are prohibited, like, for example, industrial fishing, extracting cumada shrimp in corralitos, and some activities that could pose a risk for sustainability of these resources. In order to exert artisan fishing in Ecuador, first we need to have this fishing permit abiding by to the law, and this is also acknowledged through the type of vessel artisan fishermen use. Those vessels are classified according to the law and pursuant to regulations.
I want to send our deepest appreciation to um, um, Deputy Aguinaga for submitting the video. She took the time to provide us with a brief overview of the new Fisheries Act in Ecuador, just to make sure the full video with the English translation will be made available in full at the ELI website. We will try to put it just along with the recording of the full webinar as we usually do. So on that, and with again our thanks to our PGA colleagues, I want to move on to talk with a couple of colleagues that have much broader experience on how the management of small-scale fisheries is working in specific countries. And we will be starting with the Vice President for the Philippines and Pacific Islands for RARE, Rocky Sanchez Tirona. Rocky is a RARE's Vice President for the Philippines and the Pacific Islands, spearheading the implementation of RARE's global initiative, Fish Forever, in these two geographies. She is the leader of a team of more than 35 staff who are working with local and national leaders to manage coastal fisheries more sustainably. The Philippines program has worked with almost 90 different coastal municipalities over the course of the last decade. building capacity in community-based fisheries management with an emphasis on science, governance, financial inclusion, and behavioral change. She's also leading the rollout of a global training hub for Fish Forever country teams across RARE. With that, Rocky, thank you so much. I know that it takes a special effort for you to join us from the Philippines at this time of the day there. So all yours. Thank you very much.
Thank you, Xiao. Hello, everyone. I'm very happy to be here. Please don't worry about me, Xiao. I've had my coffee, so I am all set, I think. So I'm sharing my screen, and I just want to double check that you're all seeing the screen share version and that it's advancing. Did it advance? Because that's the other thing that has been. Did it move from a cover slide? No. Okay, hang on a second, because this always happens with me these days. I just need to do it another time. Okay. All right, I think I'm good now.
Yep.
All right, I'm
That
very
looks good.
happy to be here, and I just want to preface this presentation really by saying that when I saw the toolkit, I actually got very excited because it really speaks to everything that we're trying to do in our program. So I really felt like, okay, this is going to be easy because I'm just going to explain why it works for us. And for those of you that are not working in fisheries, I just wanted to provide a little bit of scene setting. This is Jaime, and I hope you do see a photo of a fisherman. So Jaime is a fisherman in Lubang Island in the Philippines, and he represents what are called municipal fishers in the Philippines. That's his boat. It's about 3 gross tons, and he goes out every day with another companion, and they go out and they catch rabbit fish and flying fish. About on a good day, he will bring home about 5 to 10 kilos of fish. So this is an example of a small scale fisherman in the Philippines, and Jaime is among 50 million or so small scale fishers all over the world who actually catch half of the global catch, and 85% of the catch that is for human consumption. And in case you don't know, it really is that there are 2.9 million people that rely on fish for at least 20% of their animal protein. And that really makes small scale fisheries a huge sector. And as everyone has mentioned previously, it's also really relevant to SDG 14. The other reason why we've focused on small scale fisheries is really from a conservation perspective. Coastal fisheries are really where people and biodiversity meet. In the 12 nautical miles from shore, where most small scale fishers operate, this is also where we find 100% of the mangroves and 85% of the world's coral reefs. So there is a very important reason to be focusing on this area. But as Leila mentioned previously, small-scale fisheries has really been an under-prioritized sector. It's been called the forgotten fisheries. They've been seen as too small or too disaggregated, that they're just too hard to manage, right? And there's a lack of data that prevents the prioritization, and so it doesn't register on the GDP of a country, and people don't quite realize just how big it is. But a lot of the studies that have been done that have been trying to estimate the size of this sector really point to a need to really manage and focus on this sector much more broadly. So RARE is a conservation organization. We are operating in 8 countries, implementing a program called Fish Forever. So Fish Forever is really our coastal fisheries program. And right now we are we are in Honduras, Guatemala, Brazil, Mozambique, Indonesia and the Philippines, and then recently in Palau and Micronesia. So for Fish Forever, there are really some core principles that we're trying to put into place. And that's really based on the problems of small-scale fisheries, which is really that we see that there is a need to really kind of stress and replace priority and preference for local communities. Seeing how disaggregated small-scale fisheries are, the only way you can really manage them successfully is if the local communities themselves have the incentive to manage their fisheries better, and that because they're the ones that are actually benefiting from this. And then at the same time, there really is a need to strengthen the role and the capacity of the local governments, because they're really the ones closest to these communities. And then from a science perspective, an important piece of the mix is really making sure that there are no-take reserves that are optimized both just for protection of the habitat, but at the same time for production, so that you're really optimizing the fisheries for the communities. So with this, second, okay. Fish Forever is actually a system approach to a complex challenge, all designed really to put into place community-based management. But it has multiple elements that are involved, including the networks of reserves that I had mentioned earlier, and managed access areas, and then having the management bodies that are that have the capacity to oversee these, who have data so that they can make the right decisions. And then that's all anchored around community engagement and behavior adoption, and then making sure that there are policies that are in place to actually enable all of this, financing to sustain it, and then at the same time, supporting the fishers through financial and market inclusion to make sure that they actually have the protection against crisis and shocks, so that they can actually engage in the fishery. So it's a mix of elements, but I wanted to highlight a few of these which are particularly relevant to policy and regulation, which the toolkit speaks to. So what the first two elements are really around that network of marine reserves combined with managed access areas. So our goal is really to have these no-take zones that are properly sized and located, that are informed by science, that are networked at the right scale. Whether it's a bay or a seascape, the science needs to kind of factor that in to make sure that we're looking at species, larval dispersal, how the ocean currents move, etc. And then at the same time, these darker blue areas and light blue areas are really the managed access areas where certain groups of people are fishing in there, and you're regulating the effort equitably, so that becomes the incentive for these communities to actually fish more sustainably. So that combination, and I'm just going to quote from the strategy that we had developed previously, is really about building local capacity to enable management bodies to legally establish and maintain a limit on fishing effort over a specific area. So it's very specific about the need for a legal instrument. And we're starting to see that play out in reality. In the Philippines, we've decided to focus that primarily on the municipal waters, which are already in the law. So they're from 0 to 15 kilometers. Local governments do have authority over their municipal waters. So that becomes the managed access area. In Indonesia, there's no such law. So it is about working with the province that has jurisdiction over the waters and asking them to designate the areas from 0 to 2 nautical miles as the managed access areas. So in every country that we're working in, we're trying to understand what the context is, and then trying to see what the opportunity is for establishing these managed access areas. In Micronesia, for example, where we're just getting started, and we're still doing the landscape assessment, we think it's going to be a combination of the Indonesia's approach, where it's the state that has jurisdiction over the waters, but at the same time, there's a very established protected area network that's already in place, and it could be the potential overlap of those two areas that become the focus of the management. The other piece is really around effective management bodies, so really establishing and strengthening legal and functional management groups that can ensure transparent, equitable, and representative decision making over the coastal waters. So this is also very key. And in every place, we also have to understand how these management bodies will sit or nest within larger governance systems and spatial planning units. So most of these small-scale fisheries are also within national protected areas or within broader fishery management areas that have been designated at a national level, and trying to understand how these overlaps can be managed, taking into account as well things like customary law communities as well. So in Indonesia, we are looking at we actually have had to establish management councils. In Mozambique, there are existing fisher community councils that are the starting point, but they're not assigned to specific managed access areas. So it's kind of like matching that. In the Philippines, they're called many different things. In some places, we have to establish a management board. In other places, there is a Fisheries and Aquatic Resource Management Council. But trying to figure out what the matching is between the management body and the managed access area, I think is critical to actually having a system in place. And in all those cases, there needs to be a legal instrument that designates these management bodies with the authority to do this. Even for things like data for decision making, very important here are, aside from habitat and fisheries health, which are the biophysical surveys, is really having fisher registration and catch data, and having the systems in place that actually, I guess, that compel fishers to be part of that database, and making sure that that's updated on a regular basis is going to be critical. And in most cases, that also requires a regulatory framework and policy. And right now, we're also seeing that in the different countries that we're working in, we're approaching it from different levels. In some places like Palau, where it's relatively small and kind of easy to manage, the national government has actually agreed to put into place a national fisher registration system to register all the fishers at one time. In a place like Indonesia, where it's really very complex and many different provincial governments, we may have to do it first at the provincial level and so on. In the Philippines, because it's the devolution is more advanced, it really happens at municipal levels, but it needs to speak with the national government's system. So there are things like that need to be factored in. And then for policy and governance, really, our principal aim is really to support the devolution of authority over coastal fisheries from the centralized government control to a community-based management model. And we recognize that this is a process, and it really isn't something that's going to happen overnight. And in most cases, it'll really be a mix. But what's happened with Fish Forever is that we've done the legal assessments and tried to understand really what the pathway is for co-management over time, and that's how it's going to play out in the countries that we're working in. So I think maybe just to close, I just wanted to recap a few of the insights that we've gained from the work that we've been doing, which is also very relevant to the toolkit. It's really that the context varies, but the key principles are shared across countries, and to actually implement it what's needed is really to understand and then to work at the different levels of governance. It's really kind of being able to see what is in place in a particular area and then seeing what's needed to enhance that or roll it out to previous places, or in some places we do have to start from scratch. So that's really, I guess, the nature of kind of trying to do the same thing in multiple countries. And the need is obviously there. The demand is very high. People have been requesting for this kind of work, and in the places that we're working in, we've had to provide a lot of that support of helping to write ordinances, helping to draft legislation. But the available support is limited, and that's why I think this toolkit is just so valuable, because then there's really so much, it's so much clearer, especially for places that don't have the kind of resources to do this. So I'd like to end with that, and happy to take questions later on. Thank you very much.
Cool. Thank you so much, Rocky, for this excellent presentation, and for Rare's work on this field, which is so unique and, in my personal view, so important. We will go on with the presentation from our last panelist, Rocio, but before that, I wanted to remind everyone that you can submit your questions anytime by typing in your questions on the Q&A section of the Zoom app. So please feel free to do that. So moving on, we will be now hearing from Rocio Parra Cortez. Last but not least, of course, our friend and colleague Rocio is an academic and a PhD candidate at the universities of Alcalá de Henares in Spain and at the Center for the Law of the Sea of the Pontifical Catholic University of Valparaíso in Chile. She's an expert in environmental law with a focus on ocean and coastal management and governance, fisheries and aquaculture, and on the governance of indigenous and local fisheries dependent communities. She has been a consultant for many specialized organizations, including the FAO, WWF, and the Pew Charitable Trusts. Rocio, thank you so much for joining us, and please go ahead, the floor is yours.
Thank you, Xiao, for this opportunity, and thank you, Rocky and Leila and Marcela, to be able, I am really pleased to be able to share this opportunity with all of you. And here I'm gonna put the presentation in the, I think, yeah. So there you see all the presentation. Okay, so today, as we have been able to hear, we are speaking about the so important issues related to small-scale fisheries, but in a wider comprehension, it means how we manage the fishing resources or the coastal and marine resources in a sustainable way, understanding that so many people depend on the marine and coastal resources. So because I am from Chile, and Chile is such a coastal country with such a long coast, obviously for us, the importance of speaking about co-management has been a very important issue this last, I would say, this last decade, but especially this last decade. We had a new or a modernization of our coastal and fishing law at the beginning of 2010, 2011. And since then, we have had the opportunity to start to developing different co-management tools. But as we will see during the presentation, there are in different levels of development. So, well, first of all, just to highlight some issues about Chile, about my country. And as you can see, this long and narrow, narrow country, because it's not that narrow if we understand it in an insular way too. And we have 15 regions. And from that 15 regions, 14 are coastal regions, and with more than 100 cities that are coastal. And as you can imagine, the importance of the relationship between fishery communities is very, very transcendent. And something that I needed to put in the first place is this aspect of constitutional rights and duties. And why? Because as we are speaking about these legal assessments and to understand the legal system in Chile, it's quite important at this moment because we are going through a very important time in our constitutional system, because we are under process to have a new constitution. But the last constitution that was made during the dictatorship, it recognized some aspects that we could see that maybe they are good in one way. But the problem, as you may think, is that obviously it recognizes some important issues. For example, the right to live in an environment free of pollution, and also establishes the duty of the state to preserve nature. But in the other hand, even though it recognizes economical freedom, sometimes the conception of property rights and the free access to all sources of goods has established as a sensation for the people that they are not, the common people are not able to access to, for example, natural resources in the proper way. It's just a sort of a commodity. So that's a very important issue for the fishing area, the fishing agenda, because for the artisanal fisheries, that's a very high issue. In one way, they claim to have more rights, but rights that are recognized in a good way, in a co-management way. So that's why I think, for example, this important report that Eli has given us and all the tools are really important, are very important highlights and inputs to the discussion that, for example, here in Chile, we are having at the moment. So here are some aspects about the fishery general law. It recognizes some, we could recognize at least 3 big issues. In one way, the regulated activities, and it recognizes fishing, aquaculture, research, processing, transformation, storaging, and commercialization. So then we can see all the process of fishing and aquaculture, but then also recognize the importance of the different spaces that are involved, and the regulated agents and the stakeholders. Then we can see that the law recognizes some general principles, and this is very important because, as I was telling you before, in 2011, then the law was modernized, was actualized, and then it recognized these 4 main principle approach. In one way, conservation and sustainable use, precautionary approach, ecosystem approach, and transparent, public, and responsible management, which obviously we assume and we recognize that it are very important principles. But the problem is that obviously there is a gap from what it is recognized and what is implemented. and how especially how the public agents understand this in a way that is implemented correctly, and also how artisanal fishers especially can assume that are part of them and they can ask and claim for them. In the relationship between, or in the way that the law recognizes the institutional framework, we can recognize at least three, the most important institutions, because the fishing framework in Chile is quite complicated, but I think that at least it's important to know that all the system is under the economical ministry. And then there is the Undersecretary of Fishing and Aquaculture, which is in charge of the regulation and management. And also there is the National Fisheries Service that is in charge of the monitoring, control, and surveillance. And then when we have, I have been able to show you this quite in a fast way, the framework. I just wanted to tell you a bit about the small-scale artisanal and subsistence fisheries, because our law recognized them and regulated them in a special way. And especially about the artisanal fisheries, conceptualize it as the extractive fishing activities made by natural persons who personally, directly, and regularly work as artisanal fisheries registered in the Artisanal Fishery Register. Also legal entity composed exclusively of natural persons registered in the Artisanal Fishery Register. And this is very important because the Chilean fishing system separate the artisanal fisheries from the industrial fisheries. So inside the artisanal fisheries, we can recognize different categories: the artisanal ship owners, the proper artisanal fishers, divers, and shore collectors and algae collectors. But also inside of this huge group of artisanal fisheries, we can recognize subsistence fisheries, which has been an addition to the fishing law recently in 2019. And it understands that it is the extractive fishing activity made without any massive fishing gear and vessels, or with 7 meters overall length vessel without propulsion, whose result is the amount necessary to satisfy the consumption of the person who performs it, or his or her family. And also, and this is very important, recognize it as the activities that are made by the Aboriginal or indigenous peoples. So saying all, having able to show you in a way, in a very broad way, I just wanted to show you some tools that we have recognized as co-management in the small-scale fisheries. And here you can see at least 6 examples that our legal system recognizes. And I am only going to highlight some ideas of 3 of them. First of all, about the Biological Resources Management Plan and its Management Council. And why I think this is really interesting is because the Chilean law recognizes that it's very important to establish a co-management system among each fishery. And even though it has been difficult to implement it, I think that it's getting more and more the opportunity to get along with different people who are involved in the same fishery. So, for example, in the same council, you have people from the industrial area, from the artisanal area, from the public sector, for example, from NGOs, and then you have the opportunity to dialogue and to establish some results and some agreements about how they are gonna manage the specific fishery. And then what our law understands for a management plan, it's a compendium of rules and set of actions that enable the to administrate a fishery based on the updated biological, economical, and social knowledge. And it must contain the agreement to resolve the interaction between the different sectors involved in the fishery. And then that's why it's so important to have also not only the management plan, but also the management council, which is a consultative body integrated by representatives from the different actors that participate in a certain fishery. Then I wanted to speak a bit about the benthic resources management and exploitation area regime, which is really interesting because it's also a manifestation of a co-management tool. And it is an access regime that allocates exploitation rights exclusively to artisanal fishers organizations through a management and exploitation plan based on the conservation of benthonic resources present in previously defined geographical sectors. And this is really important because it means that the system recognizes some specific areas where only the artisanal people, fishers, especially, they can develop their activity. And this tool recognizes also, or it needs a specific plan that it's called the Management and Exploitation Area Plan, and it established a specific regime which look that the benthonic fisheries access will be regulated, tending to the conservation of those resources, and the benefits of that management will go straight to the coastal community, to the fisher community. Also, it looks for the consolidation of fisher organizations and their management capacity, and to promote it, recovering the production levels of that allocated area specifically, and the fishers improve their benefits through and they are able to organize a commercial management, being their responsibility, being themselves responsible for the operation, exploitation, and commercialization of the resources. And the third tool that I wanted to share you a bit about is the Native People Coast Marine Space, that in Spanish is los espacios costero marino de pueblos originarios, which is, in my opinion, one of the most important co-management tools that we have now. And it has been a really complicated tool with difficulties along the implementation, but in my opinion, it has been a really important way to recognize and to compatibilize different interests among the coast, especially for the Aboriginal, the indigenous people, but especially for those Aboriginal people who have developed for ages the fishery activities. And this tool gives the administration of a specific geographical sector of the coastal area to an indigenous community or a set of them through a use agreement in an indefinitely period, which is really interesting. And also, it recognized that even though the responsible of the administration will be the Aboriginal community or the set of them, their plan can also recognize some other users. So what it means that, for example, people who are not Aboriginal, but they have developed or they are developing different uses inside that sector, they can also keep on doing them only if they are going to be under the idea or the main object of the original plan. So this means that all the system needs to establish a co-management agreement, which in my opinion is a really, really challenge opportunity to show the importance of getting along these different interesting along the coast, and especially in the fishing area. So as we can see in Chile, we have been developing our system, our legal system has developed or has recognized these different tools. And we are in an interesting moment because we need to understand that the management of our fisheries and the marine and coastal resources is a common work, a common issue. So I think that, and I try to see these different tools in a very hopeful way, understanding that it's the only way that we will be able to pursue the or to obtain the SDG 14 in a completely way to 2030. So that's it. Thank you very much.
Thank you so much, Rocio, for this excellent presentation. Chile is a fascinating country for us to do legal research on small-scale fisheries. In a way, it has gone through a process that we are hoping to follow in other countries, in which you identify a regulatory system that seems to work, and then you scale it up, and then of course, all sorts of things happen, and in some other cases it's successful, some others is not. But lots of interesting legal instruments under the Chilean law, as you have described. So we do have still a little more time, a few more minutes for questions. I see a few questions on the Q&A box. I also received a question on the chat, and I also have a couple more questions. So if it's okay with you, Sophia, I know, Sophia, you were prioritizing some of the questions. So if it's okay with you, we can go ahead with the questions we have on the Q&A, and then I can take it from there for the rest. So so I see, like, actually the first question is, both Sophia and I are best in the best position to address it. Since you made the toolkit available, have you had the opportunity to work with any countries on legislative revisions? And if so, has it been working as you had hoped in guiding their drafting process? So thanks so much for that question. We are actually starting a project that focuses specifically on the implementation of the small-scale fisheries toolkit. This is for the Pacific region, and we are thankful to the Pacific community, SPC, for partnering with us on this project. So I think that the answer to your question is there's work in progress, not still too recent to see where the process is going, but from my perspective, I think it's good that instead of having us work directly with a number of governments, we are partnering with a regional multi-governmental institution that has much more experience than us and has a specific team working on fisheries governance on the member states. And so we will be coordinating directly with their team in addressing the needs and the potential regulatory reforms of countries in the Pacific. The list, the specific list is that we have included for the project includes the Cook Islands, Fiji, FSM, Kiribati, the PNG, Samoa, Solomon Islands, Tonga, Tuvalu, and Vanuatu. And as I was mentioning, the project just started last week. So we will be we are excited and hopeful to move forward with that project. So the next question is for Rocky, from actually our good friend David Donat-Katin, the Secretary General of PGA. So what is the experience of RARE in liaising, I'm hoping I'm pronouncing this correctly, liaising and, as the case may be, cooperating with members of parliament who may represent the communities of fishers in which RARE operates? Have there been situations in which local communities asked parliamentarians to change a certain legislation or a rule affecting their interests? And of course, as Leila said, our PGA small team and large membership looks forward to cooperate with RARE and to continue the excellent cooperation with ELI, especially on the basis of the toolkit.
Hi, thank you, David. That actually your question is very timely. In the past, we have not had to do that with parliamentarians, mainly because of the devolved system of government in the Philippines, where much of the policies that we've had to work with in order to put the managed access areas in place have really been done at the municipal level. So it's the municipal councils that we've had to work with. But recently, a member of Congress passed not passed, but filed a bill that could be very detrimental to small scale fisheries, which is to allow commercial fishing inside municipal waters in certain cases. And this is something that has had our communities very worried and concerned. And so they've actually reached out to their parliamentarians or their members of Congress that represent them to kind of really make sure that the hearings are done properly and that they speak up in Congress to represent their interests. So we've been providing technical support to these parliamentarians to give them the right information. So I think that's one good example of ways that we've had to work. And then another thing that's happening right now is actually one of our mayors has been pushing for a bill, a national bill to provide support and incentives to coastal law enforcers. And so he went to his corresponding congressman and they filed the bill. And that's now kind of moving forward. And the organization of legislators in the country have actually approached us to help kind of promote the contents of the bill and get support for it. So those are the kinds of things I think that we've been interfacing.
Thank you very much, Rocky. I think that another question that I received has more or less been addressed by Rocio already, because it was making reference to the constitutional process going on right now in Chile. But I just was wondering if, Rocio, if you would like to share a few more thoughts on where do you see that going, especially if what is going to happen with some of these legal instruments that you described, and if where are you seeing the conversation going on right now, especially on the protection and sustainable management of ocean resources?
Thank you. That's a very interesting question. And I think this is a very important opportunity for the community from a bottom-up approach to understand how to develop and how to think legally, how we want to have a legal system. And it's very difficult, very challenging, and very risky at the same time. But even though it has these so many different aspects, it's very, very, it brings us a lot of hope and stability. Yes, and stability, especially because obviously we understand that all changes comes with this sort of instability, and especially for us who are lawyers, we also pursue the security, the legal security, and sometimes we understand the rule of law as this very strict system. But then when we understand, especially, and I'm really glad that Chiao, you spoke first about the environmental rule of law instrument and how the United Nations has been getting along in relationship also with the SDGs, and the understanding that law is an instrument that has to help to develop people and to develop society, and especially to develop the ecosystems. So in my opinion, for us Chileans, this process that we are going through, it's a very important process to understand the way that we want to relate, for example, relate with the environment, with the not properly set natural resources, because it's not only a way of seeing environment as resources, but we understand in a good way that we human people need those resources to live, and we are blessed to understand that we have to assume a role of stewardship, but not a way of exploitation and depletion of the environment. So in my opinion, if we are able, for example, to see some other experiences in the constitutional regimes, for example, to understand that biodiversity needs to have a specific protection, not only in relation to the human being, but as its own, understanding that the protection of, for example, the marine resources or the marine, I would say, and I will dare to say this in English, but maybe in Chile will be a bit difficult, but to say that we are a coastal country and we don't have any mention of coastal or marine or ocean aspect in our constitution. And if we speak about food security, and if we speak about to combat the poverty, obviously fishing and marine resources are really important, especially for the most needed communities. So if we understand that in a way that the environment needs to upgrade the protection, I think it's a good opportunity in the Constitution. But at the same time, I understand that this is not a confrontation between development and protection of environmental protection. I think that's a false dichotomy. Because that's not the idea. The idea is not there is a confrontation. When sometimes when I speak about these issues, I have been able to speak in different debates, and people say that, so you don't want development, you don't want that people would get a better wealth. And I'm saying, no, I'm speaking about wealth, but in a good wealth, that people will have the necessities, I don't know the word, but suplidas, that they will cover their necessities, but that the most rich people will understand that it can be against the natural resources, it can be against environment, because if we don't look and take care and steward and be stewards of our environment, that's not going to be the way, because at the end of the day, we're going to deplete our marine resources, and we are going to deplete our forests. And at the end of the day, what are we going to do? Especially if we think about countries, as Rocky was saying, countries like Indonesia, like Philippines, like Chile, with climate change effects. Obviously, we need to assume a different way of how, for example, in our area, in our agenda, how legal and constitutional systems answer to that problems. That's why, sorry, because it took me so long to say this, but that's why I think this is a very important opportunity for Chile, and it's a very important opportunity because it will be the first democratic constitution that we will have in our country. So this is a long period, a long process, We hope in April, we will elect the constitutional members. It will be 155, and they will have a mandate for 9 months to be writing the text of the constitution, and then at the middle of 2022 we'll be having a new election to approve or not the new text. So that's going to be a very long period, but it's really interesting to see how the people, because this is a people issue, the people has put this, not the not the status quo system. I don't know if I'm able to explain myself. So thank you.
Well, thank you so much, Rocio. And I think that that's a great way to put an end to our webinar today on a high note and on an optimistic note. I sincerely thank each and every one of our panelists for their effort and for joining us today. I know we have already gone a few minutes over the time, but thanks to everyone, and thanks to all the participants for joining in. Please stay tuned for future ocean program webinars, and also, as I mentioned at the beginning, the recording will be available on our website probably a couple of days from now. So that is all from us for the moment. Thank you, and have a good day, night, or wherever you are. Bye bye.
Thank you. Thank you. Bye, everyone.
Bye. Thank you.